Proceed.
A very warm welcome to the honorable judges, respected dignitaries, participants, and all our guests who have joined us today to witness the glorious finals of the 19th KK Luthra Memorial Moot Court 2023. First and foremost, respected judges, we are extremely delighted to have you here with us today. Honorable judges, your presence itself has raised this event's prestige to new heights. We are the court masters of this court and we'll assist you throughout the proceedings. Judges, we'd like to inform you about the contents on your table. The score sheets that you'll be using for marking the participants, the bench memo, and the moot compromise. We've also kept the memorials of both teams as well as the bare acts. Judges, we've been asked to remind you that participants have to be scored just out of 80 marks and not 100, as the teams have already been marked for their memorials. If you are ready, may we continue? Participants, I shall now walk you through the rules. Any identification of your college or institution is not allowed. You may speak only after the court master has announced your team URN and speaker code. You're advised to keep an eye out for time placards, which will indicate the amount of time that is left for you to complete your arguments. These placards will indicate the amount of time left: 20 minutes, 15 minutes, 10 minutes, 5 minutes, 2 minutes, and time up, which will be accompanied with a buzzer. For this round, the maximum team time is 40 minutes and the maximum individual speaker time is 25 minutes. There is no rebuttal available for respondents. Therefore, they can only distribute their time in 2 slots, speaker 1 and speaker 2. While the appellant has the option of distributing it in 3 slots, speaker 1, speaker 2, and rebuttal. All communication between the speaker who is presenting and the respective team has to be done through the court masters via chat. The rebuttal time is included in the total time, as rebuttal they can take is for 2 minutes, owing to the maximum individual speaker time being 25 minutes. Are the rules clear to the participants? If so, we shall proceed to the time split, starting with the appellants. If the honorable judges first.
Please.
Address the benches, Your Honours.
Yes.
A very good morning to Your Honours. Your Honours, my co-counsel and I are pleased to be appearing before the Honourable Supreme Court of Stan in the case of Varsha T versus Republic of Stan. Your Honours, we will be representing the appellant Varsha T in the present proceedings. Your Honours, we have 2 substantive submissions to make. First, that the trial court of Province B erred in holding Varsha liable for the offence of sedition under section 124A of Stan Penal Code. Second, Your Honour, that Varsha's extradition from Brittany to Stan and the order keeping her extradition to Brittany in abeyance was unlawful. Your Honour, I will be taking 20 minutes of the court's precious time to deal with the issue of sedition or the trial court's judgment, and my co-counsel will be taking another 17 minutes of the court's precious time to deal with the issue of extradition. If you would, Your Honours, like a brief summary of the facts?
Yes.
Your Honours, the Republic of Stan is a democratic developing country which has 6 provinces, and the 6th province is the Eastern Province, which acceded to the other provinces 10 years after the independence of Stan. Your Honours, historically, Eastern Province has been culturally different, and has sourced its water from other provinces of Stan, which was partly the reason that it acceded to Stan. Your Honours, the appellant Varsha T in present proceedings is a celebrated journalist and an author from Stan. And in March 2020, she published a trilogy of fictional novel which deals with a titular protagonist called Shower, who mobilizes a far northern province over demanding more autonomy from the Kingdom of Nod. Your Honours, this novel was based 10,000 years in the future. These novels sparked a controversy where people started drawing analogies between the eastern province and the far northern province and Stan and the Kingdom of Nod, after which Varsha clarified that these books were merely a piece of fiction. On 25th June 2022, a massive film which was inspired on Varsha's books was released after passing all Stan censors, and on the very same day riots broke out. During this time when the riots were happening, Varsha was in Brittany, and on the very same day in Province B, an FIR was recorded against Varsha. On 1st August 2022, Stan authorities moved Brittany authorities for Varsha's extradition. She was extradited on the condition that if she is convicted for the offence, she would not be given death penalty. Your Honours, when her trial in Province B was concluded, the trial court, partly relying on sealed material, held her guilty for the offence of sedition. And during Varsha's trial in Stan, Brittany had requested for her extradition because she was accused of fraud and other allied crimes in their jurisdiction. This request was approved by a competent court, and this extradition was kept in abeyance pending her trial here in Stan. Your Honour, this case comes as a challenge to the decision of the lower courts with respect to this issue of sedition and extradition. If Your Honours have no preliminary query, the Council seeks permission to move to arguments. Your Honours, it is submitted that the trial court erred. Your Honours, it is submitted that the trial court erred in convicting Varsha for the offence of...
Just a second. Is it the same court which has passed both the orders, or are you merging them for the...
No, Your Honour. There were two different courts. We don't know which exact court passed the order for abeyance. It's written in the fact sheets that it was a competent court. As for the offence of sedition, we know that it was a trial court in Province B, Your Honour.
So how do you merge them in the same appeal here?
Your Honour, these two have been clubbed because both the issue of extradition and sedition is inextricably linked in the present case. Your Honour, we see that if Varsha's extradition from Brittany to Stan was not lawful, as we are arguing in the present case, then the proceeding for extradition falls, Your Honour, because the very basis of it would be unlawful.
Then have you taken this point before the trial court?
Your Honour, we had... it's only after that Varsha was convicted that we come here now.
This is, I think, main ground for challenging here.
Indeed.
Yes.
Indeed, Your Honour.
That point has been dealt by the court below?
Which point, Your Honour, if I could get a clarification?
Extradition, there's illegal
Your Honour, trial court did not comment on this matter at all of extradition. Your Honour, the point of extradition was not brought up before the trial court.
There's a new point.
Will it be maintainable for this court when you haven't exhausted all your remedies?
Your Honour, under Article 136 of the Constitution, technical hurdles are not a bar. Further, Your Honour, we also bring this under Article 32 of the Constitution. With respect to that, Your Honours, we submit that there have been fundamental right violations, both in the case of sedition and extradition. And Your Honours, given that this Honourable Court is a protector of fundamental rights.
Proceed.
Yes, Your Honours, much obliged. Your Honours, we submit that the trial court erred in convicting Varsha for the offence of sedition, and consequently the judgment should be set aside. And we prove this on three grounds, Your Honours. First, that the court misconstrued section 124A, and both the criminal elements of mens rea and actus rea are not fulfilled. Second, Your Honours, appellant's fundamental right of speech and expression has been violated by government of Stan. And third, Your Honour, due process was not followed because the principles of fair disclosure and natural justice were violated. Your Honours, before I come to the essentials of section 124A, it would be pertinent to mention here that compared to when section 124A was originally enacted, over the decades, its objective has changed. Your Honours, originally the objective was to curb dissent against a foreign government. However, Your Honours, we submit that in a modern democracy, the objective no longer is to curb dissent against government established by law, but to merely protect national interest in a proportionate manner. Your Honour, it is on this background and on the principle of transformative constitutional that we submit that section 124A of the Stan Penal Code should be narrowly construed. Now, Your Honours, coming to the ingredients of Section 124A, Your Honours, like any other criminal offence under the IPC, there are two elements which have to be met. First, mens rea, and or in this case, it was the intention of creating such disaffection against the government. And second, Your Honour, actus rea, which is the actual act or the attempt to create disaffection against the government. Your Honour, we submit that Varsha had neither. With reference to the first ingredient, Your Honour, it was held in the landmark case of Kedarnath Singh versus State of Bihar, a 1962 Indian Supreme Court case judgment, that sedition of the accused is the essence of the offence of sedition. Further, Your Honour, we submit that just like any other criminal case, prosecution has the burden to prove up to the hilt this element of sedition. Your Honour, if you refer to paragraph 20 of the agreed facts, whenever Your Honours are with me, Your Honours, Varsha, explaining, Your Honours, paragraph 20 of the statement of agreed facts. Your Honours, from paragraph 20, we see that Varsha, explaining her novels and the ideas behind them, clarifies that sedition novels were merely a piece of fiction. She further clarifies that they were not a political commentary, and we get that inference because she clearly mentions that Eastern Province is not far northern province and the Republic of Stan is not Kingdom of Nod. Your Honours, she further also clarifies that she does not hold any of the beliefs of the protagonist. Your Honours, from paragraph 11 of the agreed facts, we see that she was a celebrated author. She was a regular, she was a journalist, she was a regular author, and Your Honours, we submit that this fictional story, this trilogy, was written in pursuance of her creative instinct, and unnecessary meaning and intention is being attached to this with the aim of politically persecuting her due to her close ties with the continental leaders. Your Honours, however, the appellants agree, they submit, that in cases of sedition, the element of intention is difficult to find and is usually measured or found by the conduct of the accused, which brings me to the second limb of my first contention, Your Honour, established by law. Your Honours, when the constitutionality of sedition was challenged before the Indian Supreme Court, then the court in the year 1962 upheld its constitutionality, provided that it is read in consonance with Article 19(1)(a) and Article 19(2) restrictions, Your Honours. And Your Honours, the offence of sedition was narrowly construed. It was said that only those impute expression which intends to disturb public order or public peace by resort to violent means will be seditious in nature. Further, Your Honours, we submit that the understanding of reasonable restrictions under Article 19(2) on grounds of public order have evolved over the years. Your Honours, in the 1989 case of S. Rangarajan versus Jagjeevan Ram and others, the proximity test was laid down with reference to Article 19(2) restrictions on the grounds of public order. And Your Honours, it was elaborated, which led to civil unrest. However, Your Honours, there's ample evidence in the statement of facts which says otherwise. Your Honours, we see in paragraph 24 of the statement of agreed fact that the screenplay of the motion picture was changed unbeknownst to everyone save the film crew. Your Honours, Varsha's involvement in the making of movie ended in April 2021 when she sold off her rights. Your Honours, she was not aware of the changes which were made, which led to public unrest. Your Honours, in a sedition case of Chunni Lal versus Crown, it was held, and Your Honour, it draws on a very principal and fundamental argument. It says that since intention is the requisite of the offence, when there is no element of knowledge, when Varsha did not know that these changes were being made, the element of sedition, the element of intent or mens rea is not met. Your Honours,
that movie was passed by censor board. Any censor board was
yes, yes, Your Honour.
there? Have you taken that point that since censor board has passed the movie,
Indeed, Your Honour. That
is also one of the good point for you.
Yes, indeed,
Have
Your
you
Honour.
taken this?
Indeed, Your Honour. I was just.
And the book was not a banned book.
Indeed, Your Honour. However, Your Honour, to be clear on facts, although they might prejudice me, there was an attempt to ban these books, and this brings me directly to my second contention, which is that the state has tried to encroach upon Varsha's fundamental right of speech and expression. Your Honour, Varsha's novels were a work of fiction, and she was well within her right of freedom and expression to write those books. As seen under paragraph 14 of the Statement of Agreed Facts, we see that the monologues which were written were considered some of the finest fictional speeches ever written. Your Honors, we submit that there was a lot of creative worth attached to whatever Varsha wrote. And Your Honor, in the 2018 Supreme Court case of Nachiketa Walekar versus Central Board of Film Certification, it was observed that a film or a drama or a novel or a book is a creation of art. An artist has his own freedom to express himself in a manner which is not prohibited by law, and these prohibitions are not read by implication to crucify the rights of expressive mind. Your Honor, we submit that Varsha's right to expression was restricted, and she was targeted, and she was made a victim of political persecution because of her close ties with the leaders of the continent. The state, Your Honor, by putting a criminal charge on Varsha for her fictional books, is trying to create a chilling effect to repress any sort of open discussion or political discussion. Your Honor, by trying Varsha under Section 124A of the San Penal Code, the government has shown the extent that it is willing to go to.
You have just now said that some changes in the picture, film, that was not informed to the Varsha.
Indeed, Your Honor.
So that was not the author of the book, who is the director or the maker of the film, is a main culprit.
Indeed, Your
Is it
Honor.
your
That is.
argument?
Your Honor, there has been no mention of proceedings being taken
No, just
by
said
the...
that some changes in the picture.
Indeed, Your Honor.
That was not known to the author.
Indeed, Your Honor. However, there is a real possibility that this could have been done by the film crew for their financial interest, and there could be an absence of seditious intent. Our case, Your Honor, is that Varsha specifically did not have the requisite intent to meet the offense
So
of sedition.
did you mention it in your readings specifically as to what were the differences in the novel and what were the differences in the picture, which were or which were not in her knowledge, and did you ever tell any court in any form as to whether she was not in knowledge and these are the basic changes, that's why she's not liable for this?
Yes, Your Honors, if you could again turn to paragraph 24 of the Statement of Facts. Your Honors, we see that the changes which were made were, first, the protagonist of the book's Shavar was made into a school teacher. Second, Your Honor, the element on which war between the far northern province and the kingdom of North depended was changed from Ethereum to water. Your Honor, we submit that these two were substantial changes. They were not slight changes because, Your Honor, it was Eastern Province's water dependency based on which there were element of socio-political
Tell us,
tensions.
what are the ground you are making about the some evidences has given to the court on the sealed cover?
Indeed, Your
How
Honor.
what is your argument on that point?
Your Honor, we submit that it was contrary to due process and that it was violative of the principles of fair disclosure and natural justice.
If any evidence is very crucial and that intent to create violence, that cannot be produced before the court in the sealed cover?
Your Honors, we submit that it took away her right to defend herself, and Your Honor, it was violative of...
Any case law, anything you have to...
Yes, Your Honor. Your Honor, in the case of Commander Amit Kumar Sharma versus Union of India, which is a 2020 Supreme Court judgment, it was held by the Indian Supreme Court that sealed cover practice is against natural justice principles and can be only used in proportionate and justified. And Your Honor, there were three pertinent observations made which would...
But what are the facts of that case which you are citing?
Your Honor, if I could just refer...
Supreme Court cases.
Yes, Your Honor. Your Honor, this was a challenge against the decision of Armed Forces Tribunal, in which the Armed Forces Tribunal had denied an application to look into denial of permanent grant, and they had said that this is not an arbitrary practice. And it is on these bases, Your Honor, that this case had come before the Supreme Court. And it was held that the procedure of producing material by the prosecution in sealed cover is violative of natural justice. And Your Honor, this was on three principles. First, that it snatches effectively away the right of defending oneself because the issues or the material is not produced before the accused person and they cannot challenge it. Second, Your Honor, it gives absolute unfettered power to the court because, Your Honor, the court can, without giving justifications as to why they have perused that material and how that's relevant, can use it. And third, Your Honor, more often than not, the power is tilted towards the party which has control over that information, and that is more often than not the state, Your Honor, as it is in the present case. And therefore, Your Honors, we submit that due procedure was violated in the present case. If Your Honors have no preliminary query, this concludes my submissions. I'll briefly recap the submissions that I have made. And Your Honors, we submit that the trial court erred in convicting Varsha for the offence of sedition because 1, the requisites of Article 124A are not met. Second, Your Honors, that due procedure was not followed. And the government of Stan violated her fundamental right of speech and expression. Your Honors, I would now call upon my co-counsel to deal with the issue of extradition. It was an absolute honor arguing before the bench.
Yes.
Judges, please note team you are in 1980. Speaker code 2 will now present their arguments.
1980.
The counsel seeks permission to approach the bench.
Yes, yes.
The counsel on behalf of the petitioner humbly submits before the court. The co-counsel would be taking 17 minutes of the court's precious time. In doing so, the counsel would be dealing with the second contention at hand that deals that the extradition from Brittany and the order to keep extradition to Brittany in abeyance should not be held invalid. For the ease of understanding of the court, this present contention has been divided into 3 main sub-contention. Firstly, the extradition order of appellant can be challenged in the Supreme Court of Stan. Secondly, the extradition order can be held invalid on grounds of merit. And lastly, third, the order to keep appellant's extradition to Brittany in abeyance is not valid. In pursuance of the same, beginning with the contention at hand, the counsel on behalf of the appellant submits that the extradition order of the appellant from Brittany can be challenged before the Honorable Supreme Court of Stan, since Stan has an obligation to cooperate internationally, and also secondly, since there has been a human right violation of the appellant which can be remedied by this honorable court. We submit that the countries globally respect international law today and abide by the principles of justice, equity and good conscience. In pursuance of the same, it is submitted that Stan legal system highly regards Indian laws and also places substantial reliance on the United Kingdom, on the European Union and also on the United States of America. All these nations cooperate internationally amongst themselves to maintain and promote international peace and security. The Council stated all of these legislations in pursuant of the argument that keeping in consideration the provisions of the following countries which have a substantial persuasive value in this very court, Stan should also honor the principle of international cooperation and protect the human rights of Varsha by providing her a fair hearing and a fair trial, which was of course not provided to her in Brittany, from where she has been extradited here presently in Stan. We argue that the stance that Varsha's legal remedies were to be claimed only in Brittany, and due to their exhaustion her plea cannot be heard in Stan, is against the interest of justice and equity. It is submitted that Varsha's human right was disregarded in the extradition process from Brittany to Stan by expediting the entire procedure, not giving her enough time to have an appeal, to have her own case presented before that very court, and thus the same should be remedied by this honorable court. In pursuance of these very arguments, it is submitted before this honorable court that serious human rights violations have been vetted against the appellant during extradition process from Brittany to Stan. We submit that on 1st August 2022, Stan requested Brittany authorities for the extradition of the appellant, our client in this very present matter, and it was expected that these extradition proceedings will take a considerable amount of time, since the present issue at hand for which extradition was requested is sedition. So the offense is grave. This person, our client, is also a person who has economic resources, who has legal resources, and thus they will be adequately able to present their case in front of the honorable court. We submit that taking into account all of these provisions, that appeal, the right to appeal and the right to fairly present their matter in front of the honorable court was not given to the appellant in this very matter. We present that these hasty proceedings violated laws both of the nation of Brittany, where the appellant was extradited from, and of Stan in the state that she has been extradited to. We submit that this extradition process was in violation of Article 6 of Human Rights Act 1998. It is a UK legislation para materia to Brittany, the requested state, and which provides for a right to fair trial. In addition to that, also under Article 21 of the Indian Constitution. We submit that along with violating the fundamental rights of the appellant, she was also not able to avail the right to appeal. Under Section 93 of the UK Extradition Act, 6 weeks are to be granted to this very appellant for whom the extradition request has been made, so that they can have an appeal against the order of any court. It is submitted that in the present matter, all of this appeal and the provision was only given 2 weeks. So there was no right to appeal given to this very appellant, our client, in this present matter. We say that if a procedural law is to be bypassed, something substantial has to be presented from the respondent, some substantial reason that this is why we took this very case. On the contrary, the fact sheet clearly mentions that the state of Brittany, from where this appellant has been extradited from, was under pressure. Was under pressure from the continent to not extradite this person, but they, in their own selfish interest, because this person was gaining a lot of attention for Brittany, so they, to protect themselves, expedited this entire procedure on the request of the requesting state, Stan. Furthermore, we submit that the extradition order is not valid on the grounds of merit.
So your argument is that if the 6 weeks has not been given to you for appeal, then some substantial reason should be granted to not given the 6 weeks. So what do you mean the substantial reason? What are the substantial? If the violence has created by your books and your film, that can be said a substantial reason.
Much obliged, Your Honor. To answer this very question, two substantial inputs. Number one, that the procedure is to be followed. If there are 6 weeks, then 6 weeks must be given. We say that to entertain the worst case scenario, even if those 6 weeks are not given and you have made the entire proceeding in 14 days, then these substantial reasons should be mentioned. Your Honor, rightfully, right, of course. In this very present matter, the allegation that our very client has caused sedition, our very client has caused secession over this very factor, I humbly submit at that, as my counsel has already proved, that all of these charges are false. So, if there is nothing concrete against our very appellant, why has these proceedings been expedited? The humble submission from the counsel.
I have a question. You see, what is it? What have you come to court for? How can we help? You are asking us what?
Much obliged, Your Honor. We ask you, we ask this present honorable court that since, as the case already made by my co-counsel, the trial order for conviction under section 124A is not valid, the client should be acquitted, and thus this extradition of the client from Stan to Brittany, which has been kept in abeyance for 2 months, should be quashed, and this person be sent to Brittany so that they can fight the charges against them.
But is there any point that now you are challenging extradition? Because now, once you see, it is not an irregularity, is it an illegality or it is irregularity? Once the person has come here, the person has been convicted. So, you see, you can either challenge that the sedition charges against you are not made out, and therefore under the treaty, whatever they said, that should be complied with. How can you challenge the extradition at this stage? And both of them are so intricately they are connected with each other. So can you
Order has been taken by the Brittany authorities cannot be reversed per se, because that has already happened. What we, on behalf of the appellants, humbly submit that there has been wrong caused to our very client, and because the client is of course the citizen of Stan as well as Brittany, and since in Brittany all of the fair right proceedings and of course the right to appeal has been quashed, this honorable court take that under its very jurisdiction, take that order in their very consideration and pass something so as to provide relief to our very client.
But how do we do that? You haven't answered my question. I'm saying that you see, as far as extradition is concerned, I just told you whatever I have to tell. Now, are you giving up that plea now? That since extradition has happened, so now let's leave that. Let's talk about sedition only. And let's talk about that we have
Extradition.
Possibly think on the lines that there are two separate limbs of the extradition argument.
Coming to that, Your Honor. The thing that has already happened.
The thing is the challenge of the habeas.
Much obliged, Your Honor. It is submitted that the extradition order is also not valid on the grounds of merit and should be set aside. If the council can assist the court to turning to page 7 of the memorial of the appellants, the honorable bench would find a table present there which details what are the bars to extradition. So to clear any extradition request, these bars, namely, the offense should not be of any political nature. There should be a principle of dual criminality that is followed. And of course, death penalty as a possibility or as a substantial clause should not be there. It is submitted, coming to first the offense of political nature, that in general terms, a political crime is one directed against the security of the state and would include such crimes such as sedition, treason, espionage, etc. It is submitted that in extradition law, it is generally believed that a person should not be punished for their own the political beliefs that they have, even when they are contrary to the government at their home state. In the present case, extradition was done on the basis of FIR registered under section 124A of the Stan Penal Code, sedition through and through. It is finally submitted that since the offence committed by the appellant was of a political nature, and since every legislation governing extradition, 3 prime legislation governing extradition, the UK Extradition Act of 2003, a UK treaty, para materia to Brittany, the Indian Extradition Act of 1962, para materia to Stan, and finally the UK Extradition Treaty, the bilateral treaty between both of these countries. Since this is a bar under all of these three legislations, the extradition order was passed contrary to all of these provisions.
Do you have any case law about that, challenging the extradition, what point you have just stated? Any supporting law, any supporting citation, any supporting case?
For, Your Honor?
Extradition, what were 3 points you have said that, violation of that? Granting the extradition, have you any point, any citation, any case law?
Much obliged, Your Honor. If the council could come to this query of your bench in just a minute. Much obliged. Moving on to the next bar, that would be the bar of dual criminality. It is submitted that double criminality principle says that a fugitive cannot be extradited unless the conduct for which his extradition is sought is criminal in both the requesting state and the requested state. It is submitted that the offence for which appellant's extradition took place was the offence of sedition under the Stan Penal Code, but this offence is no longer an offence in Brittany because it has been abolished by Section 73 of the Corners Act. It is submitted then that since this requirement of dual criminality is not being fulfilled in the present case, the extradition order in light of the same is faulty and violative. Finally, to entertain another merit-based contention of this present case, that there is a strong possibility of death sentence. It is submitted that certain forms of treatment or punishment are easily detected as cruel, as inhumane, and death penalty is one of them. And death penalty is one of them. It is finally submitted that since the court in Province B ruled, since the offence was punishable with death, it stood over sentencing for a period of 2 months in the fact sheet to enable her counsel to present mitigating circumstances. Mitigating circumstances for what? For death penalty. So the court is very well entertaining, the trial court very well entertained the possibility of a death sentence. In that very case, the third merit does not also hold valid. Finally, to move on to the last contention, that the order for appellant extradition to Brittany should not be kept in abeyance. It is submitted that the order for appellant's extradition to Brittany should not be kept in abeyance since there are grave human rights violations that have been advocated against her and would continue to do so if she is being kept for 2 months in this very jurisdiction. It is submitted that when in custody of Stan, she was not allowed to meet the representatives of Brittany Embassy during her stay. It is also submitted that it is in the political interest of Stan to keep this person, our client, in judicial custody for a prolonged period of time. Here it is pertinent to note that our respondent, the government of Stan, the Republic of Stan, wanted to be a part of the continent. Continent is para materia with European Union. We submit that...
Question. There's somewhere which is noted that she's a dual citizen.
Much
She's a
obliged.
citizen of both Stan and Brittany.
Much obliged, yes, sir.
How does that impact your extradition process?
It impacts it in no way. National citizens of if citizens if a person who is to be extradited is a citizen, it is no bar for extradition to any other jurisdiction. Much obliged. It is submitted that since the Republic of Stan wanted to be a part of the continent, and the continent did not want the Stan in its entirety to be a part of the continent. They only wanted the eastern province. European Union, paramateria to the continent, has certain conditions that they see in a state so as to qualify it to become a part of the continent. Those conditions being that the country should be a stable democracy, that the country should have a prevalence and practice of rule of law along with a functioning market economy. As also argued by my counsel, there existed grave cultural differences in this very present country, and the dissatisfaction of people was to such an extent that the minute they got a creative freedom instinct and the minute they got a way to express all of that dissent, it came into force, and of course secession took place, assassination of an elected representative took place, currency depreciation happened, human lives along with infrastructure also fell. We make a case that it is in the political interest of Stan then to make our client a scapegoat for all of this and say that our nation had nothing to do with it, much obliged, that our nation had nothing to do with it, it is this appellant who has caused this sedition, due to which all of these conditions has happened, and thus to make that very contention. To sum up all of the contention that the council have made, it is humbly submitted before this honorable bench that the order to keep extradition order of the appellant to Brittany should be held not valid, as the extradition was done in bad faith, and Stan has an obligation to cooperate internationally and uphold the basic rights of the appellants. Also, Varsha's extradition to Brittany should not be kept in abeyance because Stan is protecting its own political interest at the behest of the human rights of the appellant. If there are no further questions, the council would seek permission to move on to the prayer.
Do you have got any citation from that query?
No. Much obliged, Your Honor. The council pleads ignorance. To move to the prayer?
Yes.
Much obliged. In light of the facts of the case, issues raised, arguments advanced, and authorities cited, the council on behalf of the appellant humbly prays before the Honorable Court of Stan to kindly adjudge and declare that 1. The extradition from Brittany and the order to keep extradition to Brittany in abeyance should be held invalid. 2. The trial court's conviction of the appellant under section 124A of the Stan Penal Code was without merit and contrary to due process and the judgment of the trial court, and acquit her for all of the offence. And or pass any other order which the bench may deems fit to be in the interest of justice, equity, and good conscience, and for that act of kindness, the council on behalf of the appellant shall be forever grateful. Much obliged. It was a pleasure arguing before the court.
Judges, please note that the applicants have finished their arguments.
Yes, yes.
We seek your permission to allow the respondents.
Yes, yes, proceed.
Judges, please note team URL 1971 with speaker code 1 will now present their case. We would also like to inform the participants that they are not required to interrupt their arguments with non-existent.
I seek permission to proceed.
Yes, yes.
My Lord, I'm Speaker 1 for the state. I'll be dealing with the issue that's with regards to sedition. I'll take 20 minutes to do that. My Lord, my co-counsel will deal with the issue that's with regards to extradition, and he also takes 20 minutes to do that, my Lord. Now, I'll just reserve 1 minute to contest the jurisdiction aspect of the problem alone, my Lord.
Yes.
Considering the fact that my learned friends have approached this court under the ambit of Article 32, alleging a fundamental right violation, my Lord, I just only want to say this. For the purpose of Article 32, which is to say that if you read the provision literally, all it takes is a fundamental right violation allegation for a case to be maintainable. However, the question in this case is a little more specific, which is whether a 32 is maintainable before a against a judicial order. In that aspect, my lord, considering the fact that there is a trial court order, there is a case, Supreme Court case, my lord, A.R. Antale versus R.S. Nayak, where this position is clarified, which is to say that against a judicial order specifically, an Article 32 petition is not maintainable. However, my lord, in the interest of securing fundamental rights for a citizen, if this court does choose to entertain this petition, my lord, I'll move on to the case with merits. Now, my lord, the fact is essentially this. I'll present a very brief timeline that I've as list of dates over here. March 2020, Varsha releases her fictional trilogy. My lord, there exists a Republic of Stan with 6 provinces called Province A, B, C, D, E, and the Eastern Province. These provinces are dependent on Eastern Province for the purpose of facilitation of trade, and the Eastern Province is dependent on the rest of the 5 provinces for the purpose of water. Now, my lord, in Varsha's novel, there exists a Kingdom of North with 6 provinces, Province 1, 2, 3, 4, 5, and the Northern Province. These 5 provinces are dependent on the Northern Province for the purpose of trade, and the Northern Province is dependent on the 5 provinces for the purpose of Ethereum. Now, my lord, I'll just present 3 points on the fictional novel because this is very material for me to present the case for the state. There is a titular character, a heroine, whose name is Shower. She's a mobilized warrior. She initiates a dialogue with the rest of the 5 provinces to assure that there is more freedom granted to the Northern Province. That's point number 1. Point number 2 is, she ensures that the Northern Province is able to manufacture Ethereum on its own, thereby ensuring that the Northern Province is self-sufficient and no more dependent on the rest of the 5 provinces. My lord, combined with these events, my lords, in the fictional trilogy, there exists a war, riots. Towards the end, my lord, Shower dies, and she ensures the economic destruction of the rest of the 5 provinces of the Kingdom of North, and then the Northern Province becomes an independent province. Now, my lord, the point to note is this. The second the fictional trilogy was released in March 2020, debates started to spark up, with obvious parallels being drawn from the trilogy and the status quo in the Republic of Stan, which is who needs who more, whether the Eastern Province needs the 5 provinces more or the 5 provinces need the Eastern Province more. This saga goes on. In February 2022, my lord, the movie, The Chronicles of Shar, is released. And as enlisted by my learned friends, there are again 4 material changes made in the movie, which is that Shower is a school teacher. The movement begins by enticing school children. The story happens on Earth, and Ethereum is substituted to water. Now, what my learned friends conveniently did not present before the court is that, if I may draw your attention to paragraph 22, my lord, of the Moot proposition. My lord, they had stated that the movie had changed the storyline and that Varsha had no clue about this. My lord, that is not the case. Paragraph 22 very clearly says, I'll just read the first 2 lines alone, my lord. Varsha gave several interviews during the production of the film where she had told a prominent film critic that from what she knew, the Chronicles of Shower was the closest that any film had come to the philosophy of her novels. My lord, this is the lead author acknowledging
But Mr. Consul,
yes,
for suggestion, the book has authored by was not banned. The board has cleared the picture.
Yes, my lord.
As I asked the other side also.
Yes, my lord.
The censor board has tested all these things, parameters.
Answer that question on a twofold.
Just to add to that.
My lord, the argument is essentially, I'll split it into 2 parts, my lord. As for the fact that post the release of the novels itself and not waited for the movie to be released.
Correct.
My lord, the answer is as simple as this. My lord, there was lack of timely action on the part of the state. We disagree with the fact that the censor board in fact cleared this film. And the cost we are paying is the ensuing consequential riots post the release of the film post 25th June 2021. But the fact remains, for me to prove a claim of sedition against an accused, I need to prove 3 things. Publication of content with the intention to cause disaffection. That's all. As long as I can prove that Varsha intended to cause disaffection while she released the novel in March 2020, I succeed in a claim under the ambit of 124A.
What is the date of release of the novel and what is the release of the film? What is the difference with the
Well, the date of release of the novel is March 2020. The date of release of the film is 25th June 2021.
more than 1 year?
More than 1 year.
So no violence if the people have read the novel.
Malad, to reiterate that argument, there need not be necessarily any kind of violence or riot for me to establish a case of sedition. This provision very clearly says excites or attempts to excites. So as long as I can prove that there was an attempt to cause disaffection, as long as I can prove that she indeed had intention when she produced those novels in March 2020, I succeed a claim under the ambit of 124A, my lord.
Yes. Yes.
Well, so the argument is essentially this, which is that though these material changes was made by the movie, the very fact that she gave and acknowledged that the material changes capture her philosophy to the closest. Well, these material changes are removing the fictional element from her trilogy, which is that Ethereum is directly substituted to water. The story now actually happens on Earth. And whatever Varsha intended in her fictional trilogy, she almost achieved, my lord. There was an ensuing war within the 6 provinces. Eastern province almost became self-sufficient with regards to water. There was almost an economic destruction of the rest of the 5 provinces when the continent suspended talks with the rest of the Republic of Stan. She succeeded, or to put it more accurately, she almost succeeded with regards to whatever she had said in her novels when she released those novels in March 2020. I'll just get to case law.
What was the situation between the relations between all the states before she wrote the novel?
Well, the answer to this is the accession agreement between the 5 provinces of the Republic of Stan, A, B, C, D, E, and the Eastern province was signed in 1950. Now, my lord, the accession agreement had 2 main conditions, which is that...
No, I didn't ask that. What I meant to say was that she writes a novel.
Yes, my lord.
You are again and again, what you are arguing is that she intended.
Yes, my lord.
Intended. That you were trying to make her an accused.
Yes, my lord.
Please make out a case that she was an accused. She knew, she intended, she had the menstruation, she knew that I'm writing it, and this writing is going to, and how will she know a film will be made on this? She won't know. I will just write a novel. I won't know a film will be made on it, and people are going to act on it, and they're going to act so badly on it. So how, again and again, when you say she intended, please make out a case.
Yes, my lord. To prove my intention, the context again matters, my lord, which is why I started with the accession agreement. The accession agreement, which was signed in 1950, has 2 clauses, which is that the 5 provinces, since they don't have access to any kinds of ports, will be dependent on the Eastern province for the purpose of trade, and they pay an old fee for it, and the Eastern province is dependent on the 5 provinces for water. Now, my lord, the point is this. Since 1950, till the release of the novels and till now, the concept of old fee and the fact that the Eastern province is the most developed province and that Eastern province alone forms part of 35% of GDP of the Republic of Stan, and that this 35% of GDP of Republic of Stan is not shared with the rest of the 5 provinces. It's only enjoyed by the Eastern province. All of these, my lords, were well-known facts when the accession agreement was signed. They were controversial topics since 1950. That's the point I'm trying to make.
However,
yes, my lord.
Just to buttress the point which the learned bench has made, how do you retrofit a subsequent event into a prior intention formed at an earlier point of time? You are basically, your grievance and cause of action for whatever the situation arises later after the riots break out.
Yes, my lord.
Right? And now you're retrofitting an intention to somebody, imputing an intention in the human mind in 2 years back.
Yes, my lord.
How do you answer that?
My lord,
Because otherwise, if the intent was there at that stage,
yes,
so
my lord.
there's a series of subsequent events. What you need to answer, where does the causation break?
My lord,
There's a breaking of the causation here.
as I said before, the breaking of the causation need not be necessarily a visible violence or a visible riot, which is why I stuck to my point, which is that post the release of the movie only, there was ensuing riots. We concede to that. It's an undisputed fact. But the question over here is, while the release of the trilogy in 2020, did Varsha have the intention to attempt to cause disaffection against the government? as long as there was intention to cause that, as long as I have evidence to prove that there was enough material for her to know that this is a controversial issue, while she wrote that material and published.
Did she produce the film?
Bullet?
Did she produce the film?
She did not produce
Did
the film.
she script write the film? Did she do the screenplay for the film?
Indeed not, my lord.
Okay, therefore she was not connected with the film.
She was not connected with the film.
Now what happens is, just a second, so therefore you have to answer that.
Yes,
because
Parag.
your whole idea is about her comment post, everything emanates from the comment post the films.
Yes, my lord.
So that's why I'm asking.
So, my lord, she is not connected to the film to the extent where the film did go through an independent script writing process. It's not her contention that she spoke to the directors and asked them to alter the storyline of the. In that regard, very clearly states that unbeknownst to everyone, almost everyone save the film crew, it went through an independent script writing process and the following changes were made. Varsha's interview, which says that this film comes closest to capturing the philosophy of my novel, therefore that was indeed her philosophy. If she indeed believed that Ethereum is not water, if she indeed believed that all of these occurrences were actually to discover that the section aims at rendering penal discussion, advocacy, incitement. The state is not against discussion. The state is not against advocacy. It is only when discussion and advocacy leads to the level of incitement. At that point of time, my lord, that content must be deemed seditious or must be deemed violative or 19.1a or that 19.2 kicks in. That's the rationale in essence that the Supreme Court prescribes. No, my lord, considering the fact that the fictional trilogy in our case, my lord, there are monologues, fact sheet presents monologues of Shar where she questions and mocks the rest of the 5 provinces of the eastern of the concept of old fee. All of these, my lord, go beyond the point of discussion and advocacy. It instills the fact that obvious parallels were being able to draw. After the immediate release of the novels, there was no need for any riot or any violence to establish that point. So just to sum up in 30 seconds, my lord, the argument is essentially this. The fictional trilogy was released in March 2020. The movie was released in 25th June 2021. The question of law is whether there was seditious intent on part of Varsha for the purpose of causing disaffection against the government. Considering the facts of the case and the arguments that I've presented, the answer is a very clear yes, my lord. If there are no further questions, my co-counsel will deal with the issue that regards to extradition.
Yes.
Much obliged, my lord. It was an honor to argue before this court.
Yes, yes.
Judges, please note the you are in 1975. Speaker Code 2 will present next.
My lords, am I audible?
Please.
If I may begin. My lords, this is counsel number 2 appearing on behalf of the state here to advance submissions on the issue of extradition. My lords, before I move on with my extradition argument, primarily I'll lay down 3 major facts and then go on to my submissions on maintainability and then advance my arguments on merits in this particular regard, my lords. On 25th June of 2022, an FIR was registered against Varsha in Stan for offences under the ambits of section 124A of the Penal Code. My lords, based on this particular FIR, all the requisite red corner notices under the ambit of Interpol were issued based on the fact sheet, and on 1st August 2022, the state moves for extradition, files a request with Brittany. My lords, on 14th of August 2022, merely an extradition agreement is entered between the 2 countries, stating that we won't invoke the death penalty if required to do so, my lords. My lords, this is the primary misdrive when Varsha was extradited. Merely states that the guarantee by Stan that the death penalty will not be invoked was given on the 14th of August 2022. With that in mind, my lords, if there is no evidence on the fact sheet that states that the requisite time period for filing an appeal is not given, the entire argument of procedural irregularities fall apart on that note alone, my lords. My lords, this leads me on to my second contention with regards to maintainability. My lords, the order is given primarily by a court in Brittany with regards to extradition, post which it's forwarded to the Secretary of State in Brittany. The Secretary of State, with all his wisdom, looks at all the evidences available, looks through the provisions of the Extradition Act of 2003 that applies in that particular country, and allows for extradition, passes an order. Based on such orders, the person is extradited from Brittany to stand, my lords. In this ambit, under the ambits of 32 or 136, no petition can lie. If I can come under the ambits of 136, there needs to be an order, judgment, or any determination of a court in India. This is neither a court in India, nor is it even a court with regards to the Secretary of State's determination in a foreign country. If such is the case, this court does not have the jurisdiction to entertain this particular petition under the ambits of 136. Even if I go and assume that they come to this honorable court under the ambits of 32, my lords, the reality is this. This honorable court is not vested with the power to issue a writ to a foreign authority and apply the fundamental principles of the Indian constitution, or rather the Stans constitution, to any court or authority present in Brittany. These are the twofold submissions that dictate why this particular petition should not be entertained either under 136 or 32, my lords. My lords, if this discussion on maintainability is satisfactory to the bench, like to in arguendo proceed on merits in order to argue the case in detail, my lords.
You proceed on merit.
Indeed, my lords. My lords, three major considerations are required for any extradition agreement to be valid, my lords. Initially, a request has to be made from the requesting territory to the requested territory, which in this particular case is Stan, which is given to Brittany. This particular request should contain the details of the individual, the details of the offense, with all the requisite evidences to make a prima facie case, my lords. Based on this particular prima facie case, the courts in Brittany, as in this instant case, will look through, see on a summary basis if a case can be made out at all, and then pass an order, my lords. It is based on this particular determination that the court undertakes are the three relevant points with regards to what the petitioners / appellants have argued in this case come into the picture. First is the rule of double criminality. Second is the whole idea behind the political exemption. Third is whether the human rights of this individual are violated. My lords, I'll first issue my arguments with regards to double criminality. My lords, the understanding of double criminality stems from this understanding that whenever a person seeks to be extradited from country A to B, the conduct of the individual should be an offense both in country A and country B. My lords, on this particular note, if I may be as bold as to request the bench to turn to flag 10 of our compendium. My lords, this is Norris vs. USA, which is a Queen's Bench judgment issued in 2008. My lords, if my lords are with me in flag 10, the highlighted paragraphs reads as such. It is possible to define the crimes for which extradition is to be sought and ordered in terms either of conduct or of the elements of foreign offense. That is the fundamental choice. The court can be required to make the comparison and to look for the necessary correspondence either between the offense abroad for which the accused extradition is sought and an offense here, or between the conduct alleged against the accused abroad and an offense here. For convenience, these may be called respectively the offense test and the conduct test. My lords, internationally, the offense test is not considered because of the understanding of two reasons. One, all countries may not have the same laws, and even so, a court cannot be said to stand to look at the similarities between two laws because that will be improbable. Therefore, the conduct test is taken into account universally based on the decision here and in a plethora of other decisions, my lords. Why is that relevant? My lords, the conduct of Varsha as far as Stan is concerned will fall under the ambits of sedition. My lords, but that's not all Varsha is charged for. Varsha is charged for sedition, for criminal conspiracy, as well as waging war against the state, my lords. Therefore, the burden on the prosecution as in the state of this moment, as well as the burden that the courts in Brittany would have looked at, is whether there can be an act in Brittany that would fit within the ambits of Varsha's action. For that, I present to this honorable bench the provisions of Section 1 of the Terrorism Act of 2006. My lords, this act in Brittany essentially makes a twinfold distinction between terrorism and terrorism aiding activities, my lords, much like what UAPA does as far as Stan is concerned. My lords, it talks about encouragement of terrorism. It says, This section applies to a statement that is likely to be understood by a reasonable person as a direct or indirect encouragement or other inducement to some or all of the members of the public to whom it is published, to the commission, preparation, or instigations of acts of terrorism or convention offences. But also, to draw parallels between the facts of the case and this particular provision, Varsha writes a novel, takes into account what happens in Stan as on that date, grossly amplifies the problems between the different territories in the state in her novels, and now says that the titular character will encourage acts of terrorism, will poison the water supply for the rest of the country, and then say this is a novel that's fictitious and then it's a novel for independence alone, which cannot be accepted, my lords. Mere changing of couple of facts like water to Ethereum or the fact that it's set 10,000 years in the future cannot be said to have a fictional element alone to it, and therefore falls under the ambit of a statement that's likely to be understood by a reasonable person, my lords. Any reasonable person reading the novels can indeed make a connection that this is an allegory or rather a description of what happens in contemporary Stan society. Therefore, the first requirement under this particular act is satisfied. My lords, the second requirement as of this particular act is whether an action took place based on these instigations, my lords. As already alluded to by my co-counsel in this particular regard, actions did indeed take place, except at a later date. However, the fact that certain responses took place as a direct consequence of Varsha's actions, Varsha's words, are undisputed. In fact, my lords, a team of sappers who were former military officials and former military practitioners in that particular country go ahead and try to poison the water supply of the rest of the territories in Stan based on what's given in the movie and the novels. The only thing that guided them is Varsha's initial novel's work that stated that shower died and polluted all the water supply for the rest of the country and independent.
Any character of any novel, act, how can you can say that as per the section we have read just now, the encouragement of the violence and encouragement of terrorism. Any character, suppose a character in the film is shooting somebody, you can't say that is instigating the people to shoot the people.
Indeed not, my lords.
Therefore, if are any supporting judgment or these things to support your argument, such type of the authoring the books are fall in that section which are reading just now in this.
My lords, I'll still have to refer to Shreya Singhal as cited by my co-counsel, my lords. My lords, the distinction that Shreya Singhal drew with regards to discussion, with regards to advocacy, and with regards to incitement carries this particular connotation. The connotation is this, my lords. I put forth a work that's entirely fictional. That means that someone has to go through hoops and hoops of logic in order to relate to it. That is discussion, that can be advocacy, my lords. But if a reasonable person who's reading the novel can clearly see that there are 5 provinces, there's a dispute with the other province that exists at the end of the territory, that there's a problem.
You are suggesting that the author has propagating that all these things?
Indeed, my lords.
By way of the giving the seminar or the interview and all these things, then you can say that. But only authoring the book, how can you support from the ratio which are citing the citations? I think.
My lords, if I may be
explain further.
Indeed, my lords, if I may explain in that particular note, my lords, Varsha authors a novel. It's not entirely fictitious because, as we've already established, it's set in a world that is very similar to Stan. It has the same problems that Stan has. Varsha includes within her work statements that says that the other provinces are bad, that the other provinces don't know how to live their life, and that the other provinces are feeding off of the northern province in this particular matter. This directly caters to the problems associated with Stan here. Already the people are going through discontent with regards to each other.
What you're saying is what she did not do directly, she's done indirectly.
Indeed, my lords, the intention still remains. Just that instead of saying that this particular event happens today, she merely says it happens 10,000 years in the future. A normal person can draw the distinction and say that 10,000 years in the future is mere fictitious element that's masking the seditious attitude that Varsha has exhibited to her work, my lords. Therefore, the criminality element, double criminality element is satisfied, my lords. My lords, in fact, it's to be noted that the second condition that the appellant and petitioner have argued before this honorable bench is the whole idea of political exemption, my lords. My lords, it's to be noted that the entire case happened within Brittany under the ambits of the 2003 Act of Brittany, my lords. to be noted that in the Julian Assange case, when US sought to extradite Julian Assange pleaded the political offense exception. The court held as such. The treaty between the two countries was before 2003.
What is your answer of extradition that the 6 months has not been given for the appeal?
My lords,
What is your argument? How to defend this argument?
My lords, predominantly as I've already answered with regards to maintainability, it's that no piece of fact in the entire fact sheet says when Varsha was extradited. The 14th August date that they have mentioned is merely a date on which the government of Stan gave an assurance the death penalty will not be invoked. That is a part and parcel of the proceedings. That does not mean that the extradition occurred.
The main ground for challenging the extradition, one of the main ground that the appeal period has not been given.
My lords, there's nothing stating that the appeal period was not given. Merely states that an assurance is given on 14th. It simply says on 14th August assurance is given, post which extradition occurred. This entire case in trial with regards to Stan happened. And this honorable court is sitting today in February 2023, hearing the case. No timeline is given, therefore they cannot plead and misrepresent 14th August, where an assurance was made as the date on which the extradition occurred, and argue before this bench that the timeline was not adhered to. My lords, in fact, if I may go one step further and argue about the political offense exception, they claim that since sedition is a political offense, they will not come under the ambit of political offense, but that's not the case. Like I alluded to, the Julian Assange case makes an important distinction. It says that prior to 2003, the earlier Extradition Act of Brittany had a political offense exemption. 2003 Act removed that exemption, saying that even for political offenses, we will extradite that person. Now, US put a petition stating that, look, the treaty between US and UK contains a political offense exemption and therefore that should be granted. But the courts held no. The courts held that if it's between a treaty and the 2003 Act, the Act will prevail. If an act which came later, at a later date after the treaty was enacted, and does not provide for the relief that the party seeks, they cannot fall back on the treaty and claim ignorance on the act itself. Therefore, the court held that the political offense exception is not available, which is a UK code, this is pari material to Brittany, and therefore the same actions available under the India-UK Act, or rather the Stan Brittany Act, would also falter on that particular notion, leading to the only conclusion that the petitioner had indeed put up before this honorable court on human rights violations. My lords, advancing my submissions on this particular note requires 3 points to be made, my lords. The first is the way in which assurances are made with regards to death penalty in the international community. In fact, my lords, section 94 of the Brittany Act says that if an offense is chargeable to a person where the imprisonment extends to over a particular period, or if it results in a death penalty, the state should give an assurance that A, the death penalty should not be imposed, or B, if it is imposed, it shall not be carried out. My lords, that carries forward to the general practice in this particular country as well as in every other country that adheres to extradition agreements, my lords. That is, they cannot dictate to the court and tell the court that they cannot issue a death penalty. Such would mean that this particular government is infringing on the rights of the court and traversing what the court has the authority to do so. Only thing that the state can do, which is allowed both under the agreement as well as under the act, is after a death penalty, if given, can go ahead and pardon the individual, my lords. My lords, this is relevant because of 2 reasons. As of date, Varsha has been convicted. We don't have any qualms about that. But Varsha has not been sentenced yet. The state has not advanced any arguments with regards to death penalty. It's within the rights of the trial court to allow for the petitioners to present mitigating circumstances. If tomorrow the trial court comes out and says that death penalty is not given to the individual, then the entire case falls apart. If tomorrow the death penalty is indeed given by the trial court, the state can always set aside the death penalty via the inherent powers president or the governor has with regards to pardon. This means that the entire action has been consistent, which leads on to the only allegation that can be raised against the state with regards to violation of fair trial, my lords. My lords, in order to talk about what Article 6, as alluded to by my learned friends on the other side, indeed is with regards to human rights, if I may request the bench to turn to flag 13 of the compendium. My lords, are flag 13, my lords. My lords, this is Government of Romania versus Sisu, my lords. The understanding in this judgment is they're looking at what constitutes a breach of human rights. The highlighted paragraph reads as such. It says, the correct test in relation to whether extradition was barred under Section 87, which is the relevant provision under the ambit of the Brittany Act that looks at human rights, by reason of incompatibility with the Convention Rights, which is the Human Rights Act of Brittany, is not one of what is just and proportionate, or one based on a balancing of issues. The test is one of flagrant breach. That's what constitutes flagrant breach, is that an impact needs to be put forth by the petitioners or appellant before this honorable court, stating that there is a 100% chance that a fair and free trial will not be given in this particular regard. My lords, what the appellant chooses to ignore in this particular regard is what is established in the fact sheet, my lords. If I may request the bench. My lords, apologies, my lords. If I may request the bench to turn to my lords, indeed, apologies, my lords. The argument is as such. The facts clearly state that Stan's legal system is well reputed, my lords. Stan's legal system has not had any claim against it with regards to whether or not it or any of its courts have ever prejudiced against an individual. This is the prima facie case that they should have laid down, which is not there. Second, they argued on the basis that a right to appeal was not presented, which is not the case as well. Then they argued on the case as with regards to sealed cover envelope, which as held in the case of Narendra Modi with regards to the Rafael case, that can be permitted as long as a state shows to the court that sufficient circumstances exist to protect the identity or anonymity of the documents. Therefore, there is no grounds on which, both under double criminality or under political offence exception or under the Human Rights Act, for them to question this particular integrity, which leads me on to the third limb of my argument, is with regards to what happens to the extradition request placed by Brittany on the second limb. Now, lords, if I may refer to Article 10 of the Stan-Brittany extradition agreement, it says that if there is a pending legal action against an individual, extradition cannot happen till the action is complete. Now, lords, action as far as criminal action is concerned in this particular criteria, the judgment is complete only after sentencing is done. For a person to even prefer an appeal before a court in Stan, the sentencing needs to be done. For a person to approach any honorable court, including the high courts or this apex court, sentencing should be done.
What you're saying is this is premature. They have come here. They should have waited.
Indeed, my
The
lords.
trial was over. And do you think that we should remand it back?
My lords, if such were the case, even if you remand it back, my lords, the primary consideration that they're seeking is A, that 124A and the conviction under 124A should be set aside. Remanding back does not solve that particular consideration that they place before this honorable bench. Second is the whole idea of extradition from Brittany to Stan being set aside, which, even assuming this court has somehow jurisdiction, cannot be done so because of all the circumstances that are laid before this honorable court. The one thing that the court can indeed do, if I may take 30 more seconds to sum up my arguments in this particular regard, is state that let the sentence be carried out, let the sentence be imposed, then let the sentencing guidelines come out, and then we'll hear whether the order keeping in abeyance of the extradition from Stan to Brittany will indeed be valid or not.
That's what I said.
Such is the action that we sought for, and such is the action that we are okay with, my lords, because that
that's what I
still details the request that the state makes in this particular regard. My lords, if such is satisfactory to the bench, I'd like to proceed on to a brief prayer, my lords, if not taking more than 15 seconds. My lords, with all the powers vested with this honorable court, the state humbly prays that the petitions be dismissed for want of jurisdiction on the first level. On the second level, that the state, that the court not hold that the 124 conviction given by the trial court is not valid. And on the third level, uphold the constitutionality and the validity of the extradition from Brittany to Stan, my lords. And for all that, the state humbly prays, my lords. It is an honor arguing before the bench, my lords.
Thank you.
Respected judges, that brings the respondents' arguments to an end. Please note that Team Code 1980, the appellants, speaker to reserve 3 minutes for the rebuttal. Can they present it now?
Yes, yes. Yes, sir.
Much obliged, Your Honor. Quickly going through all of the submissions that we got from the side of the respondent over here, quickly rebutting them one by one, specifically starting with maintainability. Very clear case made from the side of the appellant that under Article 136, we claim the sedition order of the junior trial court. So appeal against that would be maintainable under 36. We say Article 32 for extradition. They say extradition cannot be challenged because no writ can lie. For the Brittany courts, we say that the court's order, trial court's order of keeping extradition in abeyance. Of course, as the Honorable Court also mentioned, extradition has two folds. Extradition from Brittany, now extradition to abeyance. And thus, we appeal 32 under that. Secondly, coming to the very intention of sedition that they mention. So the counsel on behalf of the respondent mentioned in para 22 that again and again Varsha's adaptation of the work that she presents in the novel. We submit in para 24 or the fact sheet clearly mentions after she does submits to the very fact that this is the closest adaptation. One very important detail that has been missed is that unbeknownst to almost everyone save the film crew, the screenplay had changed the storyline and had made, of course, these four changes that had been made, which ended it from a fictional work to a real-based sedition, which ended it from a sedition to a real-based work, which is, of course, the liability of a minute irregularity, a minute misstatement of fact on their part. Book was released on March 2022. The movie was released on 25th June 2022, not on 2021. Why it is significant? 2 years and 2 months. What they point out to is that the respondent have clearly disregarded appellant's argument that now Article 19(2) public order restriction test stands on the proximity test. How much is the direct proximity? Not indirectly, closest proximity. It is also in the US under the imminent lawless action. There has to be a clear relation between expression and anticipated danger. That was not proven on their very part. 2 years cooling year period between the books and the movies, which led to the civil unrest. No association of the novels to the movie. Furthermore, Your Honor, we appreciate the respondent mentioning Shreya Singhal versus Union of India in this present court. Your Honor, we agree and we advocate that discussion and advocacy is protected. Incitement for the very same is not appreciated. There was no element of incitement proven from their very part. We argue that in the book, no element of incitement by violent means. There was merely mobilization of people for open discussion, for open advocacy. Further, the respondent incorrectly pins the responsibility of the song that was bootlegged on Varsha. Varsha is not the creator of the song. Sing Swell, a popular author, is the creator of the song. Just to...
Yes, carry on.
Much obliged. Furthermore, to entertain the argument on terrorism, this has to be very well understood, of course, by the learned bench and, of course, all of everyone present here, that extradition was sought only for sedition. How the plea of terrorism can come into play and be relied on is a very different altogether charge. Secondly, the government is not able to prove that there was sufficient incitement for sedition. Terrorism is a graver offense, includes a lot many other essentials, include a lot many pointers that need to be proven beyond reasonable doubt to convict, to claim that someone has been accused of terrorism. That has not been done on their part. They make a reference to the Terrorism Act 2006 of the UK. Also, there is, not mentioned by them, but the UN General Assembly resolution regarding terrorism. It mentions that terrorism essentials are that there should be a state of terror or intimidating the public for the purpose of political, religious, or ideological purposes. So they make an overarching claim that all of this is involved when they mention and when they prove nothing in specific. So just a general overstatement is made that terrorism, under terrorism, claim dual criminality, but no specific ingredients of terrorism.
Assassination of one of the characters in the article, and nobody referred to that.
Precisely, Your Honor.
Yes.
Much.
How does it help you? I thought it doesn't help you. I know it goes against you.
Much obliged, Your Honor. They take terrorism's argument under dual criminality to prove that since sedition is in this part, terrorism is in that part, so there is a offense similar to this very nature for which our appellant should be made accused. We say that such is not the case. Finally, then, yes. they say that the appeal provision, the question that was put forward, just a minute, the question that was put forward by Your Honor, that how the appeal provision of 6 weeks is being violated, they say that there is no mention in the fact sheet of such a character. We mention that there is clearly a mention. In paragraph, just quickly pointing to the paragraph 40. On August 1, 2022, I'm reading from the fact sheet, no inputs from the council sides provided. On 1st August 2022, Stan moved Brittany authorities for Varsha extradition to answer charges under FIR 17/2022. Under para 42, the extradition agreement dated 14th August allowed for Varsha to be extradited. Of course, allowed on what condition? That death penalty would not be held. But of course, this very first line had been gone. With that, I submit my very arguments. Much obliged.
Thank you, participants, for your very well thought out points, and judges for your valuable insight. With that, we've come to the end of the match. We would now request your permission to let the participants exit the courtroom.
All the best, both of them. बताइए आप लोग आई थिंक हाँ हाँ तो नंबर जरा बताइए अप्लेंट का नंबर क्या है यूआर नंबर दिस अप्लेंट इज 10 क्या था
1980
1971 रिस्पॉन्डेंट और ये हाँ अलग अलग तो ये 20 नंबर में आपको देना है 20 नंबर का एक है स्पीकर वन में 16 दिया ना ऐसे ही एवरेज दिया था हाँ ठीक है तो इसको 16 कितना देना 20 में कितना देना All are here? One is missing.
One is missing. She's
Yes,
coming.
Yes, yes.
You can start.
Yes, yes, start.
So good evening to all of you. It has taken me 30 years to reach a moot court final. And it has taken me all the years since KK Luthra Memorial Moot Court was in inception to be invited as a judge. And whenever I used to get an invite for this, I always used to tell Mr. Luthra, please invite me as a judge one day. So finally that moment has come. It has been a very tough decision to the ones that, of course, sir will announce to you. There are only few things that I, as a student of law, I can share with all of you. All of you have, both the teams have been exceptionally good, exceptionally good. I don't think at this age I would have really performed so well as both of you have done. But there are a few things that I want to share with all of you, and which we have noted, all three of us have noted, and that is this, that you see, when a question is asked and you are not taken aback, you are not baffled, that goes in your favor. When you bring a compendium of the law that you want to rely on, that helps. When you paginate it properly, that helps. When you are prepared with the kind of judge you are appearing before, as to what questions the judge is going to ask, because different people react differently, and judges are no exception. So you will know that some judges will ask you questions, some judges will not ask you questions. So when you are appearing before a judge, you should know that some questions will be asked, which may be very difficult questions. You should be prepared with those questions. You should not be taken aback. And even if you are, don't show it. Even if your argument you think is not that strong, don't be taken aback. Then there's one the most important thing that I want to tell both the parties is this, and everyone who's present who is going to be a lawyer or a judge, is this, that when you know that one of your arguments is not working, or you are on back foot, please go on back foot. And you please bring forth first the best argument that you have. Because there is no point talking about an argument which may not make an impact. So it's always better to talk about the best argument that you have. And the last is that even if your arguments are not working very well, don't even show the court that you don't have the confidence to say. Whatever you are saying, please say it with all the confidence that is at your command. And the last thing that I want to tell you is this, that I am exceptionally and incredibly happy to meet you all. And when I see you all, because I was always, I always write it on my desk, injustice anywhere is threat to justice everywhere, Martin Luther King had said. So when I see all of you and the way you perform, I know that the future of this country is actually in very, very good hands. Thank you so very much, and very best to all of you.
So before the decision gets announced, just wanted to say, I wanted to add that it's taken me 30 years to even be part of any moot, because I think moots were not very popular when we were in college. And I personally didn't participate in a moot, so maybe that disqualified me for being a lawyer, but I managed. And I think the quality of the new generation is absolutely cutting edge. We see that in courts every day. The young lawyers coming up, the preparation, the articulation is very good, as has been with all of you, the participants here. So congratulations for that, keep it up. The future of the judiciary, the future of our legal profession is in very good hands. Having been an advocate, the few things of presentation, just supplementing. One is your confidence, your body language, your ability to even work with the little material that you have. Never feel nervous about it. It takes a long time. I mean, we felt anxious even after 30 years of being an advocate and counsel when we used to go in the morning. So it's normal to be anxious. The other thing is the judge is always not read everything. You know, when you come to the courts, because we have volumes. So it's important to tell a story. Good counselship is to tell a story which percolates down to the judge's mind very quickly and then work around it. And as ma'am said, never get baffled with the question. You know, work around it, be reasonable, be able, the fairness to the court is absolutely a great leverage. The court should never feel that you are fooling around with the court. It's okay, it's good to be honest, it always works well. And I think all of you handled those questions in the right fashion on that front. So that's, so all the best to all of you. And I think all of you who participated in the last few days. So congratulations to everybody. I'll leave it to Justice C.D. Singh.
Thank you. All the best, both the team, all the participants. Thank you. That's it. Yes.
I have to add that we couldn't have managed such brilliant material when we were reading the brief. I mean, the fact that you could prepare with such expertise is excellent. The complexity of facts was amazing.
And whosoever wins and whosoever doesn't win, there will be a hairline difference in choosing somebody.
Yes.
And since I have never won a moot, so you can always be assured that if you will even not win a moot, you can be on the bench, right?
All of you are requested to remain seated, please. The chief guest has arrived.
A very warm good evening to all of you. I welcome you all to the valedictory session of the 19th KK Luthra Memorial Moot Court Competition 2023. I'd like to extend a special welcome to our chief guest, Honorable Mr. Justice B.R. Gawai, Judge Supreme Court of India, Honorable Mr. Justice Chandradhari Singh, Judge Delhi High Court, Honorable Ms. Justice Swarna Kanta Sharma, Judge Delhi High Court, Honorable Dr. Sumanya, our participants, whose hard work, dedication, and perseverance have led them to this momentous occasion and whose achievements we are all here to celebrate. Bhushan Ramakrishna Gawai, Judge Supreme Court of India. Justice Gawai enrolled as an advocate in 1985 and primarily practiced at the Nagpur government. Sir was appointed as a judge of the Bombay High Court on 14 November 2003 and became a permanent judge of the Bombay High Court, the principal seat in Mumbai, as well as benches at Nagpur, Aurangabad, and Panaji. Sir was elevated as a judge of the Supreme Court of India on 24th May 2019. Sir was also a part of the Supreme Court bench which held that the right to establish and restrictions on such a right can be imposed only by a law and not by an executive instruction. Now, I request the Honorable Mr. Justice B.R. Gawai. Ma'am, please. Delhi University in the year 1993 and enrolled as an advocate in 1994. Sir practiced in the Supreme Court of India as an advocate on record and dealt in original side, civil and criminal matters in Delhi High Court, other high courts, trial courts, and before tribunals and commissions. In the past, Sir has been appointed as Additional Advocate General for the state of Chhattisgarh, as the standing counsel for the states of Madhya Pradesh, Uttar Pradesh, and Jharkhand, as the Senior Panel Counsel for the Union of India, as the Counsel for the University of Lucknow and the Steel Authority of India. Sir has also represented the Bar Council of Uttar Pradesh and Indian Tourism Development Corporation, Council of Scientific and Industrial Research, Airport Authority of India, Coal India Limited in the Supreme Court. Sir was also elected as the Joint Secretary of the Supreme Court Bar Association and as the Honorary Secretary of the Supreme Court Advocates on Record Association. Sir was appointed as an additional judge in 2017 and took oath as a permanent judge in 2019. He was transferred to the Delhi High Court on 11th October 2021. I now request Ms. Geeta Luthra, Senior Advocate and daughter of Mr. K.K. Luthra, to felicitate Honorable Mr. Justice Chandradhari Singh. Ma'am, please. Thank you, ma'am. We are privileged today to have with us Honorable Ms. Justice Swarna Kanta Sharma, Judge, Delhi High Court. Justice Sharma is a permanent judge of the Delhi High Court. Ma'am completed her LLB in the year 1991 and obtained an LLM in 2004. Ma'am became a judicial magistrate at the age of 24 and a sessions judge at the age of 35. Justice Sharma is a trained judicial mediator and has successfully settled many cases through mediation. In November 2019, Ma'am was appointed as the Principal District and Sessions Judge, North District. And later in March 2022, Ma'am took charge as the Principal District and Sessions Judge, cum Special Judge CBI at Rouse Avenue Court. Ma'am has also authored several books for the benefit of the public at large. Justice Sharma is a fellow of the Commonwealth Judicial Education Institute, Canada. Ma'am was elevated as a permanent judge of the High Court of Delhi on 28 March 2022. I now request Professor Daksh Lohiya, son-in-law of Mr. K.K. Luthra, to felicitate Honorable Ms. Justice Swarna Kanta Sharma. Sir, please. Thank you, sir. We also have with us today Honorable Mr. Justice Anish Dayal, Judge, Delhi High Court. Justice Dayal completed his degree in law along with MA Honours at Churchill College, University of Cambridge, UK, as a Commonwealth Scholar. Sir enrolled as an advocate with the Delhi Bar Council in September 1995 and had his independent legal practice primarily before the Supreme Court of India and the High Court of Delhi for over 25 years. Predominantly in civil, constitutional, and commercial law, with special focus in the areas of media, entertainment, and sports law. Sir has also represented a number of national level athletes on a pro bono basis. Sir was designated as a senior advocate by the Delhi High Court in March 2021 and was elevated to the bench on 2nd June 2022. Now I request Dr. Rakesh Khazanchi, son-in-law of Mr. K.K. Luthra, to felicitate Honorable Mr. Justice Anish Dayal. Sir, please. Thank you, sir. Moving forward, I would like to introduce our professor in charge, Professor Dr. Alka Chawla, who is an alumnus of the Campus Law Center. Ma'am figured in the top 100 powerful women in law, a list declared by the World IP Forum in 2017 and 2021. Ma'am is a recipient of the Teacher of the Year Award in 2018, given by the Indian National Bar Association. Ma'am has also received the Women of the Decade Award by the World Economic Forum in 2022. Ma'am has authored many books on copyright law and has been invited as a resource person in many national and international universities of repute. Now, I request Ms. Ketaki Goswami, daughter-in-law of Mr. K.K. Luthra, to felicitate Professor Dr. Alka Chawla. Thank you, ma'am. Now, I request our professor in charge, ma'am, to kindly deliver the welcome address. Ma'am, please.
Thank you, Anuj. Good evening and a very, very warm welcome to all of you on the 19th edition of KK Luthra Moot Court competition. I think before I start with my welcome address, we need a big applaud for this event. It's coming to an end. I would like to extend a very special welcome to our chief guest, Honorable Justice B.R. Gavai, Judge Supreme Court of India. Sir is known for his judgments, as Anuj told you just now, across criminal, property, electricity, family, consumer forum, and all kinds of subjects. I would not go into the judgments now, which I think you as law students must see how a judge comes with a very balanced view. A very warm welcome to you, sir. You've taken time out of your busy schedule. We have with us, as you've already heard, we welcome, I'll start from there, Justice Anish Dayal, Judge, Delhi High Court. He's known for his bold, brilliant, and very, very balanced view. Thank you, sir, for accepting our invitation to be the judge for the final rounds and also to be the guest of honor for the valedictory session. I would extend a warm welcome to Honorable Justice Dhari Singh. He is a very erudite judge, which you must have seen from the final rounds when he was judging your rounds. Thank you, sir, again for judging and for coming as a guest of honor. We have amongst us, I would give a special welcome. No gender bias, but still a gender bias. We have Justice Swaran Kanta Sharma, who's an excellent academic record throughout her life, and she has written a number of books on various topics. I personally, on behalf of Campus Law Center and on behalf of all the law students and women especially, give you a very, very warm welcome. You know why I say this is, Pinky Geeta are sitting here, and they would know when they did law, it was very, very difficult for us to get into law practice. I could not, so I got into teaching. But even in teaching, there were very few women. But now you find women have surpassed all the men, though not on the dais today. But otherwise they have, as far as the teaching is concerned, advocacy is concerned, whatever you may say. We would like to have the balance in society very soon. Yes, so Geeta, that's it. So I welcome all the senior advocates. I can see a number of senior advocates, retired judges, our senior professors. Welcome to all of you. And one thing which I want to say is, sir, all your presence, whether it's an advocate or a judge or a professor, it is very, very motivating and encouraging for all our students. You need not talk to them, but your presence itself gives a lot of motivation and encouragement. That's what all the students have always been telling me. Now coming to welcoming our erudite faculty. This is all the teachers. They stand as one united family. And especially Professor Raman, Professor Gunjan, and the entire team of teachers, they stand together, and we stood together through thick and thin of this competition. We have come after 2 years of pandemic. But after 2 years, you should see the enthusiasm. I think some of the students could not come because of some reasons, but they just wanted to be here. And when I think Ketki was mentioning, the advocacy skill to be a part of this competition, to look at the Luthra family and see all alumnus from this particular center, how they are attached loyally, affectionately, providing funds to us. That's what Siddharth stands for. A big hand for Siddharth. So Siddharth has not only given us a platform for all the students to be together, to learn. They have, in fact, one thing I must tell you, Siddharth and Ketki both. They learn to dream. They learn to dream that, yes, we will be someday like them. We will be like someday like them. And not only professionally, not only the legal acumen. It's the family values for which Siddharth stands. And that is what I've always been telling my teachers and students. It is very, very rare for a brother and a bhabi to be so respectful towards their sisters, towards their siblings, towards their jijas. You know, in our normally community, people say कि जीजा लोग नाराज हो जाते हैं किसी न किसी बात पे. बट मैंने अपने यहाँ पर अपनी जो 2 जीजा हैं कभी उनको नाराज नहीं देखा. वो इसलिए नहीं देखा because of these 2 people here. So thank you so much, Siddharth and Ketki, for giving us so much of values. Now a welcome to our behind the scene people, and these are, I don't know whether they are here or not. One is of course Ketki. She is the backbone of this entire competition. And anything goes wrong. We had lots of ups and downs. Siddharth would get hyper, I would get hyper. But she was one person who would say, calm down, things will happen, everything will go in the right direction, and everything has gone in the right direction. Thank you, Ketki, for being so peaceful, calm, and 2 hyper people you had to basically balance out. Thank you so much. There have been a lot of people from Luthra office, so welcome to all of them. The past Luthra office people and the present Luthra office people, there are lots of them past. Again, I would say Siddharth stands for, I do not know what magnet he is, that people leave Luthra office. Personality plus the loyalty, all personified. Again, values to be learned from all of them. And there are some people like, I just know a name of few. Aditya, I don't know, I can't see him here. Smriti, he's outside already, still working. They're all working behind the scenes. And the trouble creator, him also I can't see. The one who wrote the moot court problem. Shri Singh again this time. Abhinav, okay. So we haven't seen him, where is he? So we have to call him, at least the troublemaker has to be seen by everyone. At least the judges should see the troublemaker, who the troublemaker is. So I welcome you all, ladies and gentlemen, to this valedictory function, which we have, I think, successfully concluded. So thank you so much, and a very, very warm welcome to all of you. Thank you.
Thank you, ma'am. Now, I know that we're all excited to hear some words from our chief guest. So without further ado, I request Honorable Mr. Justice B.R. Gawai the chief guest for the event, to come on the stage and to kindly deliver his address. Sir, please.
My esteemed colleagues from Delhi High Court, Justice C.D. Singh, Justice Srimati Swarnakanta Sharma, Justice Anish Dayal, Justice Amitava Roy, present, all the respected senior advocates, Professor Dr. Alka Chawla, the professor in charge of the Campus Law University, Dr. Suman Yadav, the in charge of the Moot Court, all the members of the Luthra family, the eminent personalities present in the gathering, and above all, my dear students, a very good evening to all of you. It gives me an immense pleasure to be with you this evening for the prize distribution ceremony of 19th edition of Mr. K.K. Luthra Moot Court competition. It's a pleasure to be with students who have come from all across the globe, and at the outset I must express my gratitude to the Luthra family for giving me an opportunity to be with you this evening for the prize distribution ceremony. When we look at the life of Advocate K.K. Luthra, the only one word that would come to mind is that what an incredible journey he had. A person born in 1925 in a small village called Mia Channu in Khanewal area of the West Punjab, the erstwhile West Punjab, now in Pakistan. Born in an agricultural family where school is not available, he has to walk 6 kilometers every day to attend the primary school. From there, he does his schooling. Thereafter, in Lahore, he does his graduation, and after partition, when he was studying law in Lahore Government Law College, he is required to shift and those bonds of partition and shift to Shimla, where the Punjab Law College was established, and complete his law degree there. A first-generation lawyer, he starts his career in 1949 as a pleader, and thereafter he becomes an advocate in 1954. Starts his practice in Simla initially, and thereafter shifts to Delhi, and within a short period, though his initial field of practice was civil law, he shifts to courts, but also gradually the High Court and the Supreme Court, and in a short span of time becomes one of the most eminent criminal lawyers of the country. One of the most celebrated criminal lawyers, but also had a very versatile personality. He had a flair for art and literature. He had a love for languages, and in his school days itself, he mastered, along with English, Persian, Urdu, and Hindi. He was an avid sportsman and wrestling. This reminds me of my father, because my father was also a wrestling and athletic champion of Nagpur University. He and the incident which came to light after his death, that he and Mr. P.N. Lekhi, who was also one of the most celebrated lawyers of the country, were shot during the freedom movement, and he pushed Mr. Lekhi to save his life. Friends, he was also associated in promoting arts. He promoted Delhi Gharana of and I am told that he used to have many musical events at his residence to promote the younger talents. His father wanted to pursue engineering, but due to the family circumstances, he could not complete his engineering education. And therefore, he always promoted his son to do whatever he wanted. Young Mr. Luthra wanted to be a lawyer, seeing one of his uncles to be a leading lawyer in the neighboring district, and his father permits him to do law. But after he completes his law, as all of us know, that in those days, law was a choice of last preference. And his father feels that why should my talented son unnecessarily go in the profession which is a last choice of many, and therefore persuades him to appear for civil services examination. He clears that examination only to honor the sentiments of his father, but after clearing it, refuses to join and started practicing. I only mentioned this fascinating journey, which is an inspiration to our generation and all of you who are starting your careers shortly. Friends, this is a story of a person who, born in a small village with a sheer dint of hard work, dedication, devotion, honesty, courage, wit and eloquence, came from a small village and rose as one of the most leading lawyers in the country. He, in the days of emergency, 1975-1977, also fought for the politicians who had participated in the struggle. We all know the famous Baroda dynamite case, wherein he had appeared for George Fernandez, who later on was a minister for defense, minister for railways, and so on. And apart from practice, he also devoted himself to social work. I am really grateful that after his demise in 1997, his better half, who also was an educationist in her own right, Srimati Nirmala Batra, she started this event to cherish his memory. I am really happy that the Delhi University Faculty of Law, in association with the Luthra family, are organizing this event on such a great scale and giving an opportunity to the young talents, budding lawyers, the budding persons who would be contributing to the society. I pay my deep respect to the memory of Mr. K.K. Luthra and explore all of you to keep his journey as a model in our career. I was told by Mr. Luthra, Siddharth Luthra, yesterday that his contemporaries were Mr. P.R. Vakil, Mr. Ram Jethmalani was also must be, I think, his his contemporary. Then Mr. Krishnakant Desai. I had an opportunity to watch the performance of three of them, since Mr. Krishnakant Desai and P.R. Vakil used to regularly practice in Bombay. And though they had reached the top of their career, including Mr. Ram Jethmalani, they never left practicing in the trial courts. So therefore, friends, this is an exemplar of how, with a determination, dedication, industry, one can reach the heights of a career, though there are very humble origins. All of you are very lucky. In our days, as I already said, the law education was a last choice. If you did not get admission anywhere, you used to get admission to the law colleges. And some of them, the government servants and the persons working in 10 to 5 used to attend the law colleges in the mornings and in the evenings and complete their law courses. As said in one of the law commissions, Malumet Law Commission, and also Justice Krishna here, that the then prevailing law schools were nothing else but factories producing half-baked lawyers which were drawn as parasites upon the society. But with the starting of National Law School, Bangalore, the things changed. Various national law schools were established in the various parts of the country. Apart from that, various colleges introduced the 5 years course. And it was a paradigm shift. You started getting practical education from your first year. Insofar as, at least I can say for myself, after I passed out my law degree, it took 6 months for me to understand that I had learned nothing in the law college. I recollect once when I was a raw junior, just passed out of law school, and my senior told me to go and seek an adjournment. And I still recollect that day. It was first week of April 1985. It was before Justice Lentin, sitting on the original site in Bombay, court number 39. And as directed by my senior, I went and mentioned, Your Lordship should adjourn this matter. Justice Lentin, he had a very pleasant personality. He laughed at me and asked me, what did you say? I said, Your Lordship should adjourn this matter. Then somebody, he came to my help and said, you don't use word should. Then I corrected myself and said, Your Lordship may kindly adjourn this matter. And this is Lentin. It is, you just smile. Yes, that's the way you say. You get this training in your initial days, and whenever you start practicing, we are really envious of you. You can start practicing from day one. That confidence is there, that courage is there. As I was telling Justice Anis Dayal yesterday when we went at one of the functions, when I had started judging the meeting competitions, when I became a lawyer, a little senior, and then when I became a judge, I was judging one of the national conferences organized by the Nagpur University at Nagpur. It was around 2006, I was just sitting as a single judge, and that gave me first opportunity to preside over a full bench in a moot court along with 2 judges of the Bombay High Court Nagpur bench when I dared to start presiding over a division bench. And then, after listening to the arguments, the hard work that they have put in, the research that they have put in, I shared with my colleagues that we should bring lawyers in the High Court to learn from these students as to how they should argue. So this new legal education system, the practical education system, has opened many avenues for you. There are various opportunities, not only the moot courts, but writing judgments, then quiz competitions, and all that. It has really changed the education system and helping the lawyers, the budding lawyers, to be a complete lawyer in themselves. Friends, I would only say at this point that learning law, or for that matter in any professional course, is not complete. Law is a course or any other profession. It is an eternal process of learning. One has to learn till end of his career. The day one feels that he has understood everything, that is the last day of his career, may it be a lawyer or a judge. As Aristotle has said it, and I quote, learning is an ornament in prosperity, a refuge in adversity, and a provision in old age. As has been said, that law is not only a profession, but law is a noble profession. We have seen that our freedom movement is dominated by the lawyers, from the persons from the legal profession, may it be Mahatma Gandhi, Vittalbhai Patel, Vallabhbhai Patel, Motilal Nehru, Jawaharlal Nehru, and so on. The social reforms in the country have also been engineered by the persons from the legal fraternity. Dr. Ambedkar was one of the greatest social reformers of his time, was a lawyer by profession, one of the eminent lawyers. And we also see that our Constituent Assembly, which has drafted a unique constitution for our country, is also drafted by a Constituent Assembly which consisted largely of lawyers and also presided by none else than Dr. Rajendra Prasad, who himself was a lawyer. And therefore, while you have many choices now, after you graduate, you have super specialties like the construction arbitration, the maritime arbitration, sports arbitration, and so on. And therefore, you have greater avenues to choose your career. But the only thing is that whatever career you choose, the prerequisites which I mentioned about Mr. K.K. Luthra are the ones that you should keep in mind. Hard work, dedication, devotion, industry. Apart from that, you also require to develop an analytical mind, because law is evolving, it is organic, it is not static. We have seen in last 73 years, the Constitution has undergone so many amendments. The law has to take into consideration the changes in the society. Ultimately, the law or the Constitution is for the citizens, is for the people. Therefore, I would only like to remind you of the words of one of the greatest President of India. If 4 things are followed, having a great aim, acquiring knowledge, hard work and perseverance, then everything can be achieved. And therefore, you must have that attitude, as Dr. Ambedkar always used to say, to have a great aim is not a sin, but not to have a very low aim is a sin. You must always achieve to have excellence in your career, whatever field you choose. And if there is perseverance, if there is industry, if there is devotion, nothing can stop you. Shortly, we will be declaring the results, and it is the only one team which will get the first position. I would like to congratulate whoever is there. I don't know, only 3 of my colleagues sitting on the dais know who are the winners. But whoever is winner, I will heartily congratulate them for their hard work, for their devotion, for their dedication. But at the same time, I would request those who will not get the first position not to be disheartened, not to be discouraged, because Aristotle has said that a person who never made a mistake never tried anything new. I came to Supreme Court about 4 years back. I'll be completing 4 years shortly. And wherever it was difficult to, before coming here and whenever I had to listen to arguments like Mr. Luthra, both Mr. Luthras, Pinky Anand and so on, and it was difficult to stop a lawyer. Then the last word I used to say is that as a High Court I can afford to make a mistake, because there is still one court which can correct my mistake. And therefore, committing a mistake is no sin, but not doing anything with a fear that you will commit mistake is a sin. And your position in the academics is not only that will guide your future career. In my batch, I was at serial number 3. The first one ended as a bail lawyer at Amravati. The second one, a very good friend of mine, was elevated directly as a district judge and retired as the judge of the High Court. I was at serial number 3. I came to High Court and now here, otherwise I would have also retired in the last year. So therefore, don't be disheartened with whatever position you get. You can always improve upon. Next time is always there. And take this competition as a foundation, as a platform which prepares you for greater challenges in your life, for preparing yourself to address the courts, to do. For we also see that there are many lawyers in the public field, even after independence. We have had many of the lawyers occupying various important positions in the political public life. They still do so. And therefore, you will have greater choices in your career. The only thing that you should keep in mind is that you have to try and keep on trying. You must have that attitude that I can and that I will. And if you have that attitude, you will never fail in life. I'm really grateful to the entire Luthra family and especially Mr. Siddharth Luthra and Gita Luthra madam. The entire Luthra family has done a human service to the student polity throughout the world for giving such a platform and keeping alive the memory of their esteemed father. The legacy of Mr. K.K. Luthra is kept alive by both Mr. Siddharth and Gita madam, who in their own right are one of the best lawyers in the country. The third generation has also started their career. And I'm sure that they will keep the name and fame of the great K.K. Luthra ever shining, ever glowing. I would only end. Mr. Luthra had a flair for Urdu. The event started with Urdu recitation by my esteemed colleague, Mr. Dulia. He distinguished between Talim and Tarbiyat. And therefore, before coming to an end, because I was given 20 minutes, I have already exceeded that. I'll only end with what Abraham Lincoln said, that, and I quote him, "The best way to predict your future is to create it." And then you can start creating it right from now. I end with the couplet of Allama Iqbal, those who would not be in a position to understand Urdu but I think their friends will translate it for them. हर तकदीर से पहले खुदा बंदे से पूछे बता तेरी रज़ा क्या है, बता तेरी रज़ा क्या है. To the Luthra family for giving me an opportunity to be with you, and I give my best wishes, extend my best wishes to all the students. Let all your dreams be fulfilled. May you succeed in whatever path you choose for yourself. Thank you very much.
Thank you, sir, for the thought-provoking address. We're grateful for the time that you took to share your thoughts with us. Your words have provided valuable guidance and encouragement to our participants, and we're honored to have had you as a part of our event. Thank you, sir. Now, the most awaited moment of the prize distribution is here. The results are ready. I request our professor in charge, Dr. Alka Chawla ma'am, to announce the results. Ma'am, please.
Still 5 minutes for results to be announced. So all of you will have to do the duty of giving away the awards. So you still have some work here. Secondly, by participating teams and students must be thinking, why did I not welcome them? Without you, the competition would not have been possible. Sir, I thought I'll tell you and all the others sitting here that we have a Moot Court Society, which is headed by the Moot Court convener, Dr. Suman Yadav. Here she is with her entire team of teachers, Dr. Rahul, Shikha, Rubina, I'm forgetting the names, there's so many of them, and then Chola Raja, Neetu, and we have around 25 to 30 executive members. They all come by certain selection process. Now, 25 to 30 people are not sufficient to hold this competition. So the moment we finish, Siddharth and Ketki are going to be on the second 20th edition. They'll start releasing the problem, and then so many things, will happen. So we needed volunteers. But because of COVID, our entire academic session has still not come to a proper, regular session. So we had lots of students who got admitted in January to the first year. And there have been a lot of volunteers, along with the first years, second years, and third years who worked for this competition. And there were around 60 teams who came for this competition. And there were 5 rigorous rounds. And after 5 rigorous rounds, only 2 teams came up before the sitting High Court judges. It is not easy for students to speak before the sitting High Court judges. It was a tremendous task. And as you said, dedication, dreaming first, and then dedication, sincerity, aim to do something have brought all of you here. So now I thought I'll announce the individual prizes first, but here I have a tussle with Siddharth. He says, no, the team has to come first. No, so I will go according to you. So the first team, the winning team, no, I will first give the runners-up team. The runners-up team is Khushi Singh, Manvi Panwar, Kritika Oberoi, from Abi Institute of Law, Mohali. They were called Team URN 1980. They get a cash prize of rupees 15,000 along with the trophy and a gift. And I would request Honorable Mr. Justice B.R. Gawai to kindly present the awards to the runners-up team first. It's an all-girls team. Mohali is a co-education institution. Yes. There's a gift also for you. Okay, you haven't made. There's a hotel voucher, 15,000 rupees. There's a trophy. There's a gift. And books from Ekta Publishers. That we have been receiving for ages now. We have the winning team, Shiva Shankar ji, Sarva Iswaran K.R. Minakshi Ramanna from Shastra School of Law, Trichy. Where are they? Please come up on the stage. They get a cash prize of 25,000 rupees. There. A trophy, a complimentary voucher and a gift. Congratulations to you. I would now request Justice Dhari Singh to please present the awards for the best and the second best speaker. So we will first have the second best speaker, which goes to Ketan Priyadarshi from Maharashtra National Law University, team number 1973. Gets a cash prize of 10,000 along with a trophy and books from Ekta Publishers, which everybody is getting. So, Ekta will provide Ekta for everyone. When all of you read, you will know that it is Ekta Publishers who's given. Now this best speaker goes to Rhythm Shrimal from Symbiosis Law School, Noida, team number 1988. He gets a cash prize of 15,000 along with a trophy and a gift. Quickly run up. I would now request Honorable... I would now request Honorable Justice Swarankanta Sharma to please present the awards for the Best Memorial. The award for the Best Memorial goes to team from Himachal Pradesh National Law University, comprising of Ankita Sharma and Ishan Singh Jain, team number 1993. They get a cash prize of 10,000 along with a trophy and books. I think they've left. Oh, no, okay, doesn't matter. So we can still give a big hand to them. So I would now request Mr. Justice Anish Dayal to please present the award for the second best memorial. So what they've written, I don't know, this is due to an exemplary performances of the teams. We have been compelled to add an award for the second best memorial. So that means it was not there initially. The second best memorial goes to team from Tamil Nadu National Law University, comprising of Sonali Priyadarshini, Ayush Shukla and Swati Pragyan Sahu. Team code 1999. They get a cash prize of 7,500 and books. Where are the books? All those who participated, whether they win or not, will not go empty-handed from here. You must have made a lot of friends, you must have received a lot of smiles, but along with that, you will receive books from Ekta Publishers. And one person from each team, please stay here till we move for tea outside, and you can collect the books on behalf of everyone. So we come to the end of the function, and we begin with 20th edition now. Siddharth, please, it's your job now.
Good evening, everyone. Thank you all for being here. And I must begin this vote of thanks by thanking Honorable Justice Gavai. Alka spoke about his judgments, but when it comes to liberty and rights, his sensitivity is unparalleled. I trouble him often enough. And the other thing which is exceptional is that young lawyers are encouraged in his court. They are treated with the same respect that all senior lawyers are treated with. And very often, he calls upon them to argue an address and makes all of us sit on the side, which means we lose out a little bread and butter. But thank you so much, sir. Never a dull moment in his court. Even when there are fireworks, his disarming smile makes us all realize that we've been naughty people, and then we quieten down and we leave, and he makes sure nobody leaves his courtroom without any stress. Thank you so very much, sir. Very kind for you to be here. A wonderful address, and I do hope all my young students will take home a lot of what Justice Gavai has said. He spoke at length about my father, but more than that, he also spoke to you about the profession and the trials and tribulations, and there is a lot to learn. And we look forward, sir, to your few years and many more. And I hope that after all of this is done, we're not going to let you leave Delhi. Thank you so much, sir. Thank you so much for accepting our invitation. It's been a real honor and privilege to have you here. Now, Justice C.D. Singh, he is a brother to me. He is very close. We had to have Justice Sanjeev Sajdeva come in at 10:30 in the night. At 9:30, 10 Ketki told me there's a crisis. Sanjeev is not well. So took me 10 minutes and I said, no, let me just call CD. And on the first call, he picks up and he said, sir, I will be there tomorrow. Bhai sahab, no questions asked. And then in the morning, I called him at 10. We couldn't connect. And before I could make the second call, there was a message. I'm coming, sir. I'll be there at 1:40. Thank you so much, CD. CD has been Justice CD Singh has been a friend of the family's, steadfast as a rock, and our association goes back more than 2 decades. He and I have traveled all over the country, had peculiar moments, and he's been a workaholic, first at the bar, not the kind of bar I visit, but the bar he's at, and the bench in Allahabad and in Delhi. And I had the privilege also that, though I couldn't attend his swearing in, that the first day he sat in the court in a division bench, that's the only time I've entered his court. I've never entered his court after that. I don't appear because of our close relationship. Thank you so much, sir, for being here. Justice Swaran Sharma has been a contemporary and started as a top-class magistrate. I've had the privilege of appearing before on many an occasion. And I know I'm at default. We've not had a judge for a very long time. As the message has been conveyed to me. But thank you so much. What a lot of people don't know about her is that she's also a very erudite writer. And 4 books, 1 on fiction. I need an autographed copy of the work, ma'am.
And singer.
Yes. That the young students can demand. We can't. But that young students can demand. And apart from that, I have seen her at different stages in her career, both appearing before in the Patiala House Court as a magistrate, then in the special court sessions, and then, of course, in the High Court. And always the same demeanor. Clear-headed, firm, polite, no nonsense, but always pleasant. Never an unpleasant moment in a court. Thank you so much for being here, ma'am. Justice Dayal and I share a common interest. We are members of the Oxford-Cambridge Society, alumnus, both of us. And before we lost him to the bench, and I say we lost him to the bench because there was a very ticklish matter that he and I were doing, which had a lot of issues about international law, extradition, criminality, domestic jurisdiction, and he has left that in our lap and gone to the other side, so we are still battling with it. But we've known each other for a very, very long time. We were on the Oxford Committee, Society Executive Committee together. And it's been a real privilege, sir, to have known you for so many years. And now, today, to have you judge our Moot Court. I know he doesn't step out on a Sunday. As he said, he told Ketkin, he says, I don't step out on a Sunday, but thank you for making this section so very kind of you. A lot of the research he has given us in that case is still used by my juniors even now. Thank you so much, sir. Alka Chawla, my dear friend, Suman, Apanjot, the entire team. There are so many of you guys, but really, really outstanding. Big hand of applause for them. The faculty and the students, Prerna, come on up here. She and her team, come on, young man. They are the pillars of this Moot Court. Every year, she's been with us for so many years, really done a great job. All the volunteers, there are few of them, the others are there, but the other team is there, but they've done a stellar job. It was very challenging because after 2 years, we had lost all the lessons because of COVID. So for us also, it's a recollection and trying to get things back in place. Thank you so much, guys. God bless you always. I have my old professor, Professor Khanna, whose baby this Moot Court is. Thank you so much, sir, for being here, always supporting us. Justice Roy is here very graciously. He has adopted us, and therefore he is very kind to us and treats us as members of his family. Justice Amitav Roy is here, former judge of the Supreme Court. There are friends, Vikram Banerjee is here, Pinky, and as they said, they're here as members of the family, not in any other capacity, and that's what we love about you. Thank you so much. There are so many others. Thank you. Thank you so much. Ashwini, Chitra, my senior Mr. Lalit Bhasin, my uncle Mr. Sethi, so many friends, I can't name them all. My Mr. Dhaya, my old friend from the CBI days, from our trial court days. Dinesh ji, where are you? You must stand up. Dinesh ji is a friend. 30-odd years association, actually 40 years association, if I count your association with my father, and he makes sure that every child, he's one of those people who came to us in the beginning and said, Siddharthji, if you're doing a moot, can I do something? Can I give books to the children? And I never had to ask him. Thank you so much, sir. God bless you. My friend Mr. Parikh is missing, Bhagwan Parikh, who gives this wonderful voucher for a 5-star hotel, 7-star hotel in Alila Diva Goa Resort for the children, the best team. We never had these options. It's a 2 nights, 3 days. I'm really tempted to go back to mooting. Dr. Mehta is here. Both the Dr. Mehtas, thank you so much for being here. You know, this competition has taken new avatars. We have friends volunteering, and this time my uncle, Mr. Avtar Singh Sethi, is here. He has said that he wants to give a special prize to various participants. So we will do that later after this is all over. He's my father's cousin. Very kind of you, sir. We have about 100 odd lawyers who volunteer every year to come and judge this moot court. It's a bit of an exercise, and lawyers come, they spend their time. They're here on Friday evenings, which, as we all know, is not a good time to get lawyers out of their party time. Saturdays through the day, and again on Sunday mornings. And over the last 19 years, we have had more than 1,000 odd lawyers who've come and volunteered and been with us, and they all come very happily so, and it's normally just a phone call. So they've been really kind. This event could not have happened without the support of the bar at Delhi and the High Court, Supreme Court, trial courts. Thank you everyone, those who are here and those who are not here as well. Before ending, I must also recall, we began this moot court with Justice B.P. Singh, Justice B.N. Shri Krishna. We've had the support of our friends of the family like Justice Amitabh Roy, who came as a chief guest and now comes every year and supports us very graciously. I also remember, sir, you mentioned Mr. Ram Jethmalani. The first time we had the moot court, he was to be the chief guest at the prize distribution. It was a fledgling competition with 16 universities, and he got stuck in Pune. So his secretary said he can't come. I said, look, I want to just speak to him once and I'll leave it. So I just picked up the phone and I said, sir, it's in your friend's memory. He called me up after 5 minutes. Siddharth, I've cancelled my plan. I'm coming. I'll be there in time for the flight. And that was the kind of people who have supported us. Mr. Lekhi used to be here every year. Aman supports us. His son Aman is here every year. I send him a WhatsApp message and he tells me, why do you send me letters? Why do you send me messages? I'll come. Just send me a WhatsApp message. Give me the date. I'll be there for the final round. And therefore, we have this wonderful support base. So I must thank each one who has been our support base. Thank you so very much. And lastly, the staff of the Campus Law Center. They work day and night. They start working from weeks in advance, and then 2 days, morning, night, they make sure that the campus is spruced up to look its wonderful best. Thank you very much to every one of the staff at the Campus Law Center. Thank you. This is peculiar. I'm sorry, I've been sent back. There is one man who's very troublesome and he's hiding somewhere. He's a man called Abhinav Sekri, a very talented young lawyer who's drafted the moot court problem. I forgot him. And Abhinav is hiding somewhere because a lot of the participants were out. They had weapons of grievous assault in their hands, so I think he skulked away. He met the 3 High Court judges before he went. But thank you, Abhinav. And of course, Raman Mittal is here, other friends are there. Thank you so much. Raman, please stand up. He's been an ace supporter. He was professor in charge and an ace supporter in this court. Thank you so much. Thank you all. Thanks, Meera. I think the children want a photograph, sir, with you, all of you. Come. Come on, all of you come.
That brings us to the end of the splendid valedictory session. I now request everyone to proceed for the high tea. I also request one member from each team to stay back to collect their books and their participation certificates.
Take all. Alka, आइए. Come sir, join us.